Welcome back to Key Point here on TV3. We're also live on 3FM 92.7, live on TV3 Ghana on Facebook, DSTV channel 279, all across the world on 3news.com. This week, founder of defunct Capital Bank, Ato Essien, has been sentenced to 15 years in prison by an Accra High Court. Mr. Essien was convicted of stealing over 90 million cedis of the Bank of Ghana's liquidity support to the now defunct institution. Now, if you recall, this comes after his inability to fully pay the said amount back to the state after agreeing to do so despite being afforded the opportunity over a number of occasions. In fact, but he was able to pay just about 37 million. In fact, he earlier paid 30 million upfront in December 2022, was required to pay 20 million as the first installment of the 60 million outstanding amount by April 28, 2023. But he was only able to pay 5 million. In May, he was given up until July 4 to liquidate his assets and pay the state 55 million. This deadline elapsed without any payment, and the state submitted a request to the court seeking a custodial sentence in line with the agreement and the terms that were in there. So that's how things played out, and how come the cumulative amount of 37 million was paid over this period. Justice Eric Chebafo, upon a request by the convict's lawyer, deferred the hearing of the application to impose a custodial sentence, and this was in the criminal case filed against him following the collapse of the bank. In fact, Justice Chebafo has also been quoted saying that Ato Essien demonstrated sheer greed and needed to pay the price for his action. You recall that in time past, he's already made a number of statements to the effect that there were attempts to buy this bank and so on. But how things have played out, what does all of this say? And especially to the Attorney General's office. Deputy Attorney General will be joining us. Questions have been asked as to if he is able to pay the remaining 53 million, then what happens next, amongst other things, which we will be talking about this morning. If you follow this particular case right from its onset to this point, you would know that it's gone through very, very interesting phases. And we'll put the timelines on the screen shortly as we go on. But this does not start with just Ato Essien. There were three individuals talking about Fitzgerald Odonko and Tetenete. These two individuals who were standing trial together with Ato Essien were acquitted and discharged along the way. Reverend Fitzgerald Odonko and Tetenete were on trial with Mr. Essien for their individual roles in the collapse of Capital Bank. Together, they were charged with 23 counts of conspiracy and stealing from the 620 million cedis liquidity support given to the Capital Bank by the Bank of Ghana to enable it to service the maturing debts of that bank at the time. Now, the accused persons at that time, according to the prosecution, opened various accounts with the Capital Bank through which 620 million cedis BOG liquidity support was transferred, while others were carried in jute bags to Mr. Essien. However, after many, many years of the trial, at the time it was 4 years, the two accused, together with Ato Essien, were freed of all the court's hurdles. The court found the two, Fitzgerald Odonko and Tetenete, not guilty of 6 and 7 charges respectively. Reverend Odonko, in his evidence, revealed that he was against the bank's payment of 27.5 million cedis as a business promotion to its founder and Chief Executive Officer Ato Essien. In the case of Dr. Tetenete, Also alleged during his trial that officials of the collapsed bank coerced him to sign certain documents when the officials were invited by the Securities and Exchange Commission. This was when the regulators commenced investigations into the operations of the financial institution. Alfred Tua Yeboah is Deputy Attorney General. He has joined us now. Tua Yeboah, good morning. Welcome to Key Point. If you can unmute yourself for me.
Yes. Good morning, my brother, and good morning to my co-panelists.
Right. Good morning. Thank you. Also, joining me in studio, Martin Pebble, celebrated private legal practitioner, one of the foremost human rights lawyers we have in this country, the convener of the Komipreko Reloaded demonstration, and then also a leader of one of three individual bondholder groups. So, Martin Pebble, good morning. Welcome.
Morning, Mr. Council.
Great. Good. Professor Enoch Enchi is an expert in governance and leadership, written quite extensively about leadership on the continent and beyond, and also is the Dean of the Communications and Business
at Academic
City University. Professor Enoch Enchi, good morning, welcome.
Good morning, Alfred, and I'm thrilled to be here. Good morning to all Ghanaians and those beyond listening to us and watching us live.
Indeed. We've also been joined by Bobby Banson, who is also a private legal practitioner, one of the leading voices, in fact, an expert in civil procedure in this country. Is also a lecturer at the Ghana School of Law. Gentlemen, always good to have you join us this morning. On the basis of this foundation that gave to this story, just for the benefit of our viewers to follow every step of the way, these are the timelines. Take a look at this. August 2017. That was the period that the Bank of Ghana revoked the license of Capital Bank and declared it insolvent. October 2019, William Ato Essien and then the others that I mentioned, their names, were charged with multiple counts of stealing and money laundering of the said amount. December 2022, Ato Essien entered into this agreement to refund 90 million cedis. After a number of back and forth in court, this amount of restitution was then settled on. All other accused persons were found not guilty of the charges as I read earlier. April 2023, the Attorney General applied for custodial sentence, saying the payment terms have been breached. And then just last week, well, this Thursday gone by, 15 years slapped on Ato Essien for failing to pay the 90 million. Now, he paid 37 million out of the 90 million. This is the breakdown of Ato Essien's sentence. Money laundering, 2 years. Stealing of 35 million cedis, 11 years. And then money laundering again, another 2 years. Stealing of 2 million cedis, 2 years. Money laundering, 5 years. Money laundering, 2 years. Stealing of 35 million, 11 years. And you see there. In fact, if you put all of this together, it's 95 years. 95 years in total. But because he'll be serving concurrently. Just let's help get an understanding of this. Mr. Alfred Tua Yeboah, so all of this put together, 95 years, but then because it's going to be serving concurrent, it's 15 years. Help us understand, especially for the benefit of viewers, how all of this, the 15 years came to being.
Thank you very much. Now, if you take our Criminal Offences Act, as well as our Criminal Procedure and other acts, you realize that if you commit a crime from a single action, you can be charged with multiple counts. It can be 20, 100, even 1,000. But if at the end of the prosecution, the prosecutor is able to prove all those counts and you are found guilty, the court will sentence you on each of the counts. And if you aggregate all the counts, you can even get 1,000 years. But because those counts arise out of a single activity or an activity that has resulted in all those counts, the court has the power to order that you serve those counts concurrently. In that case, you look at the highest sentence among the counts, and then you serve it. So in this case, you have 15 years, 10 years, 11, 2, 1. The highest among them is 15. This simply means that he's serving the 15 alongside the various sentences at the same time. So that's the reason why he's going to serve 15 years IHL.
I see. Now, did Ghana really get a good deal? I mean, the court documents estimated stolen money to the tune of more than 250 million cedis. Even that amount, if recovered, would not have been enough due to, at least if you consider the time value of money. Just 37 million recovered now. Did we get a good deal?
It is better than none. Now, since independence to date, I can say without any fear of contradiction that there hasn't been any single criminal prosecution where the state has been able to recover from one accused person an amount of 37 million Ghana cedis. In most of the cases, the accused persons are tried, they are convicted and sentenced into prison custody. They go to prison, serve their term. Some others do not serve their term, they are pardoned. They come back home and enjoy their booty. So in this particular case, having been able to recover 37 million Ghana cedis to the good people of Ghana, I think it's a very positive step. Not that one alone. The convict also failed to go by the terms of the agreement, and it's also in addition serving a jail term. If, for instance, in last year, December, the court had gone ahead straightforward to sentence the convict, what this would have meant was that the state was not going to recover anything if the state was not able to trace the properties of the convict. However, because we had that agreement with him, at least we've been able to get 37 million Ghana cedis, which if you compare it to the amount of 250, we may say that it's a bit small, but that much 250, because after subsequent searches, it turned out that indeed the accused person, there was some amount that were blocked, there was some amount that he had paid to Yoko, so we knocked all those amounts out of the entire sum, and we came to what we have at the moment. So 37 out of 90, I think, is quite reasonable. It's not up to half of the amount, but looking at our history, I will say that the state has actually made some money out of this prosecution.
But you see, Mr. Essien had indicated at a point, Mr. Tua Yeboah, that a judgment debt had made the sale of assets belonging to Essien Swiss very difficult, and that was to be litigated. Could your office not have delayed moving the request for custodial sentence a bit, considering this particular issue that Ato Essien had raised at a point during the trial?
Right. This deal was brokered in December 2022 under Section 35. Now, if you read Section 35 of the Courts Act, any breach of that agreement simply means that all the outstanding sum becomes payable. So having breached the first term or first instrumental payment of 20 million Ghana cedis in April, per Section 35, he was supposed to have refunded the remaining 60 million Ghana cedis at a go. However, the judge kept giving him some time to redeem his pledge or his promise. We were in court in May At that time, he had paid 5 million out of the 20 million. The court said, you should give him some time. In fact, I know counsel people is there, my brother too is there. If you look at section 35, the judge has no discretion to even extend time. The moment there's a breach, the judge has nothing to do apart from passing custodial sentence. But the judge kept giving him time. We went to court in June. He had added another 2 million. We were caught in July, early part of July. The court said fine, he was up to the end of July. Fortunately for him, the court then sits on the last adjourned date, which was in July, and the matter had to be adjourned to October because of the legal vacation. So he had at least 2 months to have paid the outstanding sum. We're even looking at even paying the first 20 million Ghana cedis, so that fine, the court may say, if you pay the 20 million, so give him up to maybe end of September, October to pay the next 20 million, and December we pay the last one. Perhaps we will have looked at it. But from that time up to last Thursday, he had paid only 7 million out of the outstanding 60 million. So he was given enough time. And let's also remember that this is a deal that the state reached with Ato Essien. Other people are also watching it. The moment you decide to deal with him with case glove, then people will be thinking that, oh, let me also go and enter into such an agreement with the state. After all, the state will not exactly pound of flesh. The state will go and sleep. But so far as some of us are concerned, if you agree with us, you have no problem. But if you fail to go by the agreement, we pursue you so that you respect the agreement. So that's the reason why we think that for the period that he was given, it was enough for him to have redeemed his pledge or promise.
Well, did you in any way confirm that he had properties to the tune of some $10 million, which has been reported in some articles that I have read about all of this? Did you confirm any landed property that he has to this amount, which could have been defrayed to offset the cost, in fact, the remaining of the amount which he was supposed to pay, or because he had violated the agreement of this restitution, you had to just go ahead and slap him with this custodial sentence?
When we were in court in May or June, his lawyer submitted an agreement that Mr. Ato Essien had reached some people for them to make some payments to him. And if my memory serves me right, the amount in that agreement was not more than $1 million. The amount in that agreement was not more than $1 million. So I even questioned whether even if that person were to pay that entire sum, that could be used to pay the 60 million Ghana cedis. And that's the reason why the judge even gave him more space, so that if we were able to recover the 1 million or 300,000 plus, I forgotten the amount, that could have been used to make some payment. In terms of verifying whether he had an amount, he had a property worth $10 million, he said it. We weren't able to verify it. You can say you have a property, it's worth $100 million. You can even bring valuation worth $100 million. That is not our responsibility to go and sell the property for you. No, you have to go and then sell it so that you come and then comply with the agreement. In any event, there was even a challenge when he said he had a certain property that he wanted to sell, because someone's also saying that that property has been attached in execution of a judgment against one of Ato Essien's company. So it was a bit muddy. We didn't want to go into that. And we were not interested in also getting to say, well, let's take the property and sell, because we will not be in a position to sell it. And that's not even the base of the agreement that we had. The agreement was very simple. Pay it and walk away. But having failed to pay, he was supposed to just go by what the law says, and he's now been sentenced 15 years imprisonment. But that may not even still end the matter. But that's another ballgame.
I see. But was justice not generally served? I mean, I'm looking at this, how this case has played out over the period. There are some who make the strong argument that the state, you took a political decision to let some people off the hook. Yes, clearly that Ato Essien was, together with the entire company, was mismanaging the liquidity support given to him. But then again, he kept getting more from the Bank of Ghana over the period. Are we not concerned, about those who kept approving this for him, even when there was evidence, at least per the board's report, that continuously the monies given to him were not being used for the purpose for which it was being given. Aren't you looking beyond him to look at how these monies kept coming in, even when there was evidence of mismanagement?
Yes. The history will tell you, or in this case will tell you that he was given 620 million Ghana cedis by the Bank of Ghana. Out of the 620 million Ghana cedis, almost 250 million didn't go into the reason for which that money was given. You are right to say that if someone, the person who was supposed to have checked him or regulated him, failed to discharge his duty, then that person may have some questions to answer. But as I speak to you now, there is no evidence to that effect. But if there's any evidence that someone stood somewhere, decided not to check on him, for him to use the money as he wanted, definitely there's no statute of limitation on crime. Such a person, a group of persons, can also be dealt with in accordance with law.
I mean, what evidence do you need beyond the fact that there was a clear case of misappropriation of the funds?
There was misappropriation of funds by Ato Essien, and that's why the court has dealt with him.
But yes, but then again, that act was supposed to be checked by the regulator, who was continuously giving him money, and so there was a failure on the part of the regulator. So, if you're saying that there has to be evidence for you to move beyond Ato Essien to now ask the questions of the person who was continuously, or the institution was continuously giving him money, then the point I'm trying to make is that the evidence of that act was the outcome of William Ato Essien's misappropriation. So then, what else do you need to go beyond him to ask questions of the authority or the institution that was giving him the money?
Yes, let me use this as let me cite this example. I came to TV3 for financial support for my farming business. TV3 conducts due diligence on my business and gives me an amount of, for example, 10 million Ghana cedis. I duly acknowledge receipt of that amount. I take it to my place, then use 9 million for the business. Then the other 1 million, I use it for something which is outside the scope of that business. In that case, absent any evidence that TV3 was aware that I was diverting that fund, can we hold TV3 liable and then prosecute TV3? To my mind, no. But if there's evidence that during that diversion, TV3 knew and actually was aware that I was diverting that fund, that's why you may want to hold them for also not being up to the duty that they are supposed to perform. I've given this analogy so that we can understand the situation of Bank of Ghana. I'm not saying that people may not be guilty or may not be culpable of having also committed one offense or the other. But I'm saying if we are able to get evidence that someone decided not to act, or someone acted in a way that has resulted in a loss, financial loss to the state, that person must also face the law. But currently, Ato Essien has stolen that amount. He has been dealt with, but there is no limitation on crime. At any stage, those who were in charge of Bank of Ghana during that period, they must not think that they can go and sleep. Further information may come and they may be called upon to answer.
And this further information will come from where? Is it from your own investigations, or you are relying on people to furnish you with that information as the Attorney General?
Now, you know that the Attorney General does not investigate. We only receive reports of investigation. And in Ghana, the state agencies are responsible for the conduct of investigations into crimes. So I cannot perhaps disclose to you, but the state agencies are working. And if there is any evidence of wrongdoing on the part of any officer of the Bank of Ghana, I will be the first person to call for his or her prosecution, because we need to build our nation. Nobody will build a nation for us.
So the investigation continues. It's not a case, an investigation that's ended as yet in this Capital Bank case.
All other cases, so far as even if after 50 years, there's evidence that someone decided not to perform his duty, and that has occasioned this loss to the state, that person will be called upon to answer.